So good morning, everyone. Good morning. Lots of voices in return, I think.
Good morning.
Early, but glad to have you all here. Was that Larry I heard, I think?
That was Larry. Yes. Good morning.
Good morning. So before we get started on the main discussion, just a few housekeeping things. If you could keep your mic off, that'd be great. We'll do it for you if you don't. And I'm going to be on, as you can see in the agenda, doing some introduction of BDTI and the event first. There will be, after I finish interviewing or maybe interrogating my friend Larry, there will be a 10-minute break, so we can all take a rest after that. But and then we'll resume and have hopefully a exciting roundtable discussion with other experts. So with that, I'm going to start a short introduction. Please bear with me just a minute while I'll share. Thank you, everyone, for coming. So here we go. Can everybody see that? Yep, great. Okay. BDTI. People may be wondering who the devil we are. We are the Board Director Training Institute of Japan. I am the representative director, along with Professor Osugi at Chuo University Law School, who is also on METI's Corporate Governance System Council. And we are approved by the government as a very special kind of nonprofit, a public interest nonprofit, to do the activities you see here up above. Knowledge about corporate governance, which basically is director training. And governance training at all levels, but mainly senior, of course, and research about corporate governance and increasing awareness of it. And we also have approval to do profit-making activities, which are used to fund the nonprofit activities, which include increasingly more active collection of corporate disclosure data, analysis of it, advice, consulting with respect to it. This is basically big data, particularly focused on corporate governance. So that's what we do, and we've done that since 2009. And you can come to our website. If you click here, we will send these materials out to everyone later on, so you can click on everything if you like, and you can go directly to our website, which use Google translate to English. There is an English website, but it's not as robust, shall I say, in content as the Japanese website. So you can see we have a regular governance course, and an advanced course for outside directors and e-learning and that sort of thing, and upcoming webinars. We're on a little kind of a roll of doing, gee, that's a pun, isn't it? Webinars on the role of certain people. So we recently did a webinar led by the leaders at Hitachi, who revamped their not only HR system, but also consolidated worldwide IT, procurement, and finance. Levant Arabachi and Mr. Yamaguchi, and that was on the role of HR mainly. Next, we'll have a role of the CFO webinar in Japanese coming up, where the CFO at Omron and other experts will talk about that. And following that, we'll talk about the role of director training, which obviously is close to our hearts. So please look out for our newsletter in email that we will send you. This is how our activity have grown over time. They make us very busy. As you can see here, we trained something like close to 7,000 people on e-learning. If you include e-learning, we trained at least 10,000 people over the last 12 years or so in e-learning alone. Here's our board of directors. It includes a diverse group. Women and men both, people with lots of experience as outside directors or internal executives, or in most cases both, attorneys, the former chairman of the board of governors of the GPIF, Mr. Hokugo, who is the head of corporate governance at the Pension Fund Association. So we have the investor side, and these are very dedicated people who I'm very sort of blessed with having their back support, or they have my back, or anyway, they give me lots of good advice. So I'm very thankful to them. And as I say, we're very busy with all sorts of activities. And you can see this is what we did last year. I'm sorry that it's in Japanese, but this is intended so that you can, those of you who don't speak Japanese can just send it on to as many of your Japanese friends as possible and spread the faith about what we do. As you can see, we had 16 open to the public small group courses last year, and 25, a large number, we were very busy, programs for specific firms, that is in terms of program days, webinars, all of them free, just like this one, 7 in number, et cetera, et cetera. So very busy. And the main two one-day, very intensive courses. It's a tiring day, but it's, I think, well appreciated by everyone and going quite well. We have an introductory, what we call governance Juku course, which basically gives you the minimum knowledge and perspective you need to prepare yourself more to be a director before you join a board. Hopefully you take this course. It is the basic boot camp course. We also have a boot camp, by the way, I'll show you later in English, but this is the variant of that in Japan, in Japanese. Then we have after you've taken that, if you have that knowledge level, you're allowed to take this advanced outside training, a director training course, where it's much looser framework. They're both very interactive courses with lots of mini cases and discussion. This is even more interactive, and Ichikawa Sensei and I teach this based on a replete, huge, thick binder of advice memos we received from, I guess it's 11 experienced outside directors, men, women, Japanese people, et cetera, multiple companies, and 5 different experts in various fields, ranging from audit to compensation to HR and nominations, et cetera. Here's our e-learning courses. We have modules in company law, securities law, corporate governance basics, and corporate governance practice. And for any companies that are listening, the best deal in the world, you'll never see anything better than this, is our Sky Hodai, all you can eat menu for e-learning, which means that any company, say it was Panasonic or Hitachi, whoever it is, for 300,000 yen can train, have all of the members of even its group companies and subsidiaries take 9 hours of replete e-learning, which has been well designed by experts in each field. So please take a look, if you will. That's a really a good deal, if I'm allowed to say so as a salesman. This is the English boot camp. It continues to have legs, as it were. I'm amazed because it's been going on for like 10 years now, and you would think we would have sort of used up all the demand from people who speak English, who are interested in corporate governance and serving on boards here, but we haven't. We just gave it about 2 days ago, and it was actually a very good group. We had that quite active. Recently, Oasis, a activist fund, out of the blue, gave us funds to fund scholarships for women, and 68 professional women received scholarships for our director training courses. And even without that, last year, if you look at our open to the public courses, about 42% of the participants were women. So women are really stepping up to the plate to take these courses often under their own funding. And for this course, I had to actually go out and sort of find very qualified women because some of them are reticent to take the courses, but we got great people attending the courses now. It's wonderful. A koeki hojin, or a public interest nonprofit, is this very special thing, which, when you think about it, if you understand the structure, it's very complex, but when you understand the structure, it really is the apex, the most quintessential sort of company with a purpose, which is this word bandied around a lot in ESG circles. But we really are a company with a purpose because we're not allowed to do anything other than the approved activities that I outlined earlier at the first page of this presentation. We don't have that purpose. That's the only purpose we're allowed to do. And the people who have supported us, if you're in this system, donations, particularly for domestic institutions or individuals, get a hefty tax benefit. You can also get a tax benefit in the US, by the way, through a system we've devised. But one of the reasons was a tax benefit in Japan. And I was hoping that institutional investors in Japan would support us because, we're quasi-regulated by the government that comes in and inspects our office every 3 or 4 years. And I thought it would be the most easy sort of platform for Japanese institutional investors to support But the exact opposite happened, which has been quite surprising. 99% plus of our donations come from foreign institutional investors of the like that you can see here on the right, and almost none comes from institutional investors in Japan, and none comes from large mainstream institutional investors, the names of whom you would kind of recognize all of them. So we'd like to put a call out for donations. If you support the cause of improving corporate governance in Japan, training is essential because we are in a transition phase in Japan. We are creating new practices and customs and traditions that didn't exist and weren't even being discussed 10 years ago. So just a quick sidestep here now to talk to you about the data that we are collecting and some of the things it reveals, because I think that might be interesting for folks to look at. We just are in the middle of doing analysis, the update analysis we did several years ago on, have all these changes in corporate governance in the last 7 years had an impact. And when you look, what's very interesting is if you look at all TSE first level listed non-financial firms, the financial firms aren't they're in sort of different group, not comparable to non-financial firms. Despite all of the vast differences in level of ROA in industries, between, low margin manufacturing industries and very high margin game software companies, this kind of thing, there's vast differences in ROA between those. So you wouldn't expect to see many correlations, but you actually do see a surprising number of correlations despite the intense variation between these types of firms and their economics. So for instance, what stands out here is that independence matters a lot. On the left, you can see anything in green here is something that is statistically significant. That's what the p-value means. And the R squared here sort of means, well, how much is it contributing? How much does this factor seem to be contributing to ROA? We can't say it's causing, but it's correlated highly with, let's say it that way, ROA. And what's interesting here is that, as you know, firms are allowed to have their own definition of independence that's kind of based on the TSE criteria, but in most cases, most firms have a dependence or independence criteria list, which is more lax, frankly, than the TSE criteria themselves. And lo and behold, the TSE criteria have a higher R squared than the average firm's own sort of, in general, more lax standards as independence. But in both cases, they have a significantly higher R squared than outside directors who are not necessarily all independent. That's quite striking. Independence matters. Another thing that matters is company age. Younger companies perform better. That's now that you may say that's obvious because there are game software in different industries and that sort of thing. But anyway, useful to think about. In industries you wouldn't expect, they also tend to perform better on average, is our experience. Higher pay, having at least one director with more than 100 million yen of compensation correlates with higher performance on our ROA. Now, if we look at only audit committee companies, those companies that transitioned into the audit committee style from statutory auditor style mainly, which is about 33% of companies total on the TSE1 now, we see some interesting commonalities and also some differences. Independence, once again, under the TSE criteria is very important. More important in this case. Now, my hypothesis here, just a hypothesis, is that more of these firms who transition to audit committee style tend to be, founder-led or a large investor-led sort of family invested or founded companies. And so they tend to have a higher, what we call Herfindahl index, which means there's a large owner, a very large owner, like 40% holder in the capital structure. And so as a result of that, more of them tended to sort of immediately or proactively move into this structure on average than did not. And I think that's the reason why you see this correlating highly. Now, just to understand the correlation, if we go back to the prior page where we were looking at all companies of any corporate governance structure, you could see here that the Herfindahl, so well, the way to look at this is, say we're looking at TSE criteria. This is the case when you didn't have any independent directors. That's sort of the average ROA. You can think of it this way: the average ROA if we didn't have any independent directors. And if we had 100% independent directors, it would increase by this amount, 1.85. Now, that's a big difference. So that's the way to sort of think about the numbers, if you will. And you can see in the Herfindahl index, this is what it would be if you had a 0 Herfindahl index, and this would be if it was very, very high. It would increase by this amount. So in this case, you can see ROA would be increasing by 5 to 6, up to 5 to 6%, and here would be increasing to up to 3.89% or so. Now, if you look on the next page, excuse me. Yeah, here we go. Audit committee style companies. The point I want to make is that the Herfindahl index is very powerful here. Look at the degree to which the ROA increases as you increase the Herfindahl index. That really shows we have more family style, i.e. large investor companies here who are driving shareholder value because they are big owners. Again, company age, younger companies outperform, and companies that pay more outperform. Similar results, except that this Herfindahl thing factor is more powerful, shall we say. Now, what's interesting is what these charts do not say is significant. And that is the fact that whether you have a compensation committee or a nominations committee. Okay, there's some significance here, but if anything, the correlation is negative. That's what the data is telling us in a very, very small way, in a very, very small way. And the way I interpret this is to say that, well, we have a small percentage of, 10% of listed companies where the nominations and compensation company, 20%, I don't know, of companies have these committees that are, meeting 10 times a year, meeting 8 times a year, hiring consultants, looking at a lot of different candidates and being very active in reviewing compensation and nominations policies, who should be nominated, that kind of thing, having good debates. But we have, 80% or so of companies that are just going through the paces, and that's actually reflected in the MEDI statistics, which show that in 2018, on average, these committees were meeting only once or twice a year. Say 60 or 70% were only meeting once or twice a year, and the average meeting time was something like 1.5 hours. So most of these committees are simply not meeting enough to do much of an impact, is what you have to read into these numbers, because there's nothing statistical of significance there. And if anything, it's negative. Okay, so why is data important? Well, this is a English translation of the presentation I made to the LDP after I had a lot of discussion with Diet Man Shiozaki in 2013. In 2014, in February, was invited to give a little speech to the LDP subcommittee of the growth strategy. It was a public committee with the Wall Street Journal, other people were present. Here's the English translation of my first page, and my real first page of what I spoke about was this in translated form. And I was basically saying, look, folks, if you're going to have a stewardship code, which you're now considering to do, you're going to have to consider that we don't have very much disclosure about what is happening at boards in Japanese companies. Investors cannot see into the black box of what's going on behind the curtain, to mix metaphors, of the board. And so they don't have very much data and information upon which they can analyze and which they can use to be good stewards. So you're asking them to be good stewards, but you're not giving them enough information to be good stewards, and that doesn't make any sense. The way you have more disclosure of the data they need to be good stewards is you have a governance code that not only sets standards for good practices, but also says, well, if you don't have these practices, you don't have to comply, but explain what you are doing and why you don't comply anyway. So then we have more disclosure. And so this is very much, in my mind, 50% of the reason for proposing the governance code was disclosure. This is the Japanese version of the actual language that I used. We'll send this to you later. You can read it at your leisure, but you can see how important data is to my mind. And on these other pages that you'll read later on, you feel free to read about our data activities. We've given a little bit of sell pitch here about what we're doing. Those of you who are investors, I think, will be interested. We have a lot of unique data that we find through algorithms that other people don't have. And it's all highly structured and goes back many years on a time series basis. So it's truly big data for not only corporate governance, but corporate disclosure in general. Here's where you get full database access if you want to read that later on. So that was a whirlwind tour of BDTI. I'm going to stop sharing now and start the event. So, Larry, are you there? I guess Larry will. Very good. Good to see you.
Good to see you. Good morning, everybody.
Good morning. Good evening to you.
Yes, good evening from the East Coast of the U.S.
Good to see you again. I'm going to introduce the event in the following way, just by giving a little bit of a background discussion. The position, obviously, of General Counsel has existed in the U.S. For many years. And recently, it seems that something like 10% of U.S. firms have a General Counsel who sits on the board. But either way, the role of a licensed attorney who serves as in-house counsel to the company has been a sort of a well-understood and accepted essential practice in U.S. corporate governance for a long time. And then Sarbanes-Oxley came along and elevated the role of attorneys and in-house counsel as playing an even more central role in the up-the-ladder rule, which was intended to ensure required swift reporting of malfeasance and noncompliance and that sort of thing, up to the top of the organizational hierarchy. And now we see more Japanese firms appointing registered attorneys like yourself and our other participants as general counsels. And so against that background, I hope to be exploring with you the emerging role or changing role of general counsel in Japan and what it means in practice and what difference it makes if that person sits on the board. So I'm, over the last 20 years, to introduce Larry. Larry, as we all know, I think, has served as general counsel and in other senior roles in risk and compliance at Panasonic, at Lixil, at no less than 3 different major subsidiaries of GE in Japan. So he's got a wealth of experience, and he's a good longtime friend of myself, my former ACCJ president / boss, as it were. He did an excellent job of that when I was leading a team to propose Japan's growth strategy long ago, about 10 years ago. And he's not only very knowledgeable and experienced, but he's just a very nice person. And I thought we simply cannot let you go or leave Panasonic without first tapping and recording your wisdom and insight that you've collected over the years. So, thanks so much for participating, Larry.
Well, thank you, Nick. And it's really good to be back on a so-called platform with, and very honored that it's BDTI with you after the many years we worked together in the ACCJ and in particular in the early days of Abenomics. And certainly, I want to express my condolences to everybody here about that horrible news of a few weeks ago. But those were certainly interesting and optimistic times to be working together on these sorts of issues.
Exciting times, and you were a real supporter. I must say, the most supportive ACCJ president by far on those activities that I was working on, or one of the most supportive by my memory. So thank you. So to jump into the topic, the word general counsel is sort of an imported word here in Japan, and the concept is sort of imported. What is your concept of the most important roles of general counsel that you hold in your mind when you are doing that role? What's the role of the GSC? How should our audience conceive of this role?
Well, certainly, but before I address that, I just wanted to comment on your introductory comments regarding the background, because I think it's all important for us to keep in context the fact that in the old days when I graduated from law school back in the 1980s, an in-house career or becoming general counsel of a US global company was not necessarily something that a lawyer graduating from an excellent law school aspired to. So things have really changed dramatically in those 3 or 4 decades, even in the United States. And so I don't think we can take it for granted that that's the natural course of things. I'm very proud to say that my first boss, ultimate boss in GE, Ben Heinemann, I think was very instrumental in his role as general counsel in defining what a general counsel should be and really developing that for the United States. So then to get to your immediate question, I have always looked, and it's in large part thanks to him, but I really kind of tweaked this for the Japanese context. You know, I've looked at it as really being two fundamental roles. I think first and foremost is how do we bring legal expertise in all of the different aspects of the law, whether they be compliance or transactions or employment law or any number of other things, including corporate governance, which is your bread and butter. How do we bring the right level of expertise to highest level discussions in the corporation such that those factors are taken into account with the right experts sitting at the table in those areas? And then secondly, I think because of being immersed in so many different areas like that, hopefully with the right people around us, we can also give general strategic advice, including on the company's ability, hopefully, to look around corners and see what's coming in terms of risk and opportunity that may ultimately be shaped in some fashion or another by a legal or policy or regulatory issue, but need not necessarily be. It just may be that wisdom or judgment that one develops over time,
right,
looking at all the areas that you have a voice at that table and you can see around those corners. So I look at it as those two important areas of activity.
excellent. That's a great summary. The looking at the you know, the other areas, the new areas of possible risks or emerging problems, and I guess part of that, doesn't that relate to sort of the idea of gemba, as we say in Japan, that an attorney who's in the company and, you know, very conversant or knowledgeable of the strategy and the products may be much better situated than outside counsel to do that?
Well, I think yes and no. And again, you know, the historical background of US and Japanese companies in many areas is quite different. I think it's very important for any in-house lawyer, including, of course, the general counsel, to be deeply involved in business discussions in the so-called gemba. I think if I look at my experience in Japan, sometimes we don't have enough of the other side of the equation. And in addition, which is that we also need to be able to step back and look at, you know, from an expert lens, what are the emerging trends externally that you may not pick up while you're very internally focused in the gemba. So I think it's really the right balance of both that one needs to have.
Good, thank you. So, you know, suppose, well, here's a question. You know, in the absence of appointing a person as, like yourself, as the general counsel in a Japanese company, what do you think is missing or could be missing if, you know, for instance, there's only a legal department headed by a person who's not a registered attorney? What are the possible gaps in compliance, checks, ethics, governance, whatever, that are, you know, more likely to occur, and why? Or are there any?
Well, I think you have to, if we're looking at Japanese companies in particular, I think we have to look at the rotation structure and the way that HR is developed within the company, with traditionally most people joining the company from the time they graduate from college. And they don't necessarily focus in that kind of career path on developing specializations in a particular area. So many people who do legal will not necessarily have been in legal all of their careers. I'm not saying that's a must in all positions, but I think what sometimes happens that I've tried to address in my last two roles in Japanese companies, and before that in my career in GE, in Japanese subsidiaries of GE, is how do you really develop the level of expertise, both in the individuals that you need to have in each of those areas of the law
Right.
that I mentioned, and also, collectively for the institution. Where is that expertise and how do you develop it over time in order to fulfill that, either the first or the second role of the general counsel that I mentioned. So I think what may be happening in a lot of Japanese companies, and by the way, this is not unique to Japan, I see this in even companies in the United States from time to time, but is that you may not have sufficient expertise in the leading legal roles across the different divisions or subsidiaries of the company. And that's what the company may be missing in looking at forward-thinking risk. And we may not have institutional knowledge because of that rotation system where people move without leaving the expertise they've developed, often with the outside counsel behind. And the outside counsel sometimes, end up with more expertise than we do internally. So that's kind of the conundrum I see that we need to address.
That's a really good point. I appreciate that point. Isn't there also an issue here where, if you are a registered attorney and you have something to lose, you could be disbarred. Whereas if you're not, you can be demoted or put off on a different job, but you don't have as much to lose.
Well, I don't really look at it that way so much, to be honest. I think that if I look at my experience in Panasonic and Lixil as well, there are many people who are non-licensed, or they may be licensed overseas but not in Japan, who are really deeply knowledgeable.
They're very high qualified people,
highly qualified people. So I don't look at the need for a license as being absolute. If you would ask my former boss, Ben Heineman, he would have said absolutely yes. And I could never hire anyone in GE who did not have a license. And he really strongly believed, in the case of Japan or Asia, that it needed to be a local license. And I do see benefits of that, but the benefits I see, it's along a spectrum. The benefit I see of having the lawyer's license is a little bit outweighed by the benefit of having experience using that lawyer's license in a law firm for several years. Because I think the law firm has the luxury of teaching young lawyers how to be lawyers. And in the company, we really don't have that kind of luxury with the degree of training and the infrastructure to train young lawyers to do really what it means to be lawyers. So I think the benefit of having a license is ultimately that training that is likely to come from being in a law firm for several years.
Yeah, absolutely. I can understand that. Sure. Yeah, very good point. So, if I was devil's advocate, which, as you know, I can be, and I said, well, gosh, the GC reports the CEO. He's an internal guy in the end, and so he may tend to bend the CEO's wishes. So, maybe it's better to depend on outside counsel, which has a firm name, a kanban, to protect its reputation, to protect. What would be a response to that kind of devil's advocate thought?
Well, a couple of things. I think actually the point you're just making is one of the strongest arguments for having a locally licensed in-house lawyer in the lead position, because that person then is legally obligated by ethical codes to have a different perspective. So I think that adds something to the equation. But that being said, if you're acting as a general counsel or in any senior executive position in a company, you do have fiduciary obligations, even if you're not on the board, as an executive officer level type of person. So assuming that the lawyer is appointed to a high enough level role in the company, they do have legal kind of potential liability if they don't do what they really need to do. So again, I'm not convinced that the license is a magic kind of
No,
cure-all for.
right.
But I think when I think about the combination of resources and the benefits, relative benefits at a senior level, I think it's a very valuable thing to have. But it's very difficult to find that kind of qualified person
Right.
in Japan who has all the other traits that we need to have too within the existing compensation structures.
So we need to be balanced and look for the best person we can find realistically. Great. So SGC, it would seem you have two roles, if we maybe oversimplify, and the first relates to execution matters, contracting and general compliance and the M&A deal, due diligence, whatever it may be. And the second is kind of a different category relating to proper operation of the board. For instance, when the minutes or more detailed memos and records of board meetings are prepared, or when board practices are being considered, or opining whether directors are, fully doing their duties under the law. Did it make a difference to you yourself that, or did it make a difference to anything that if you sat on the board versus not sitting on the board?
Well, before getting to that, I guess I would just say that I, with all due respect, I kind of put the corporate governance and board secretarial duties within the first role of the general counsel, which is the legal expertise area, because I do think that area is an area that requires a certain amount of legal expertise, especially in a publicly listed company where you have to be aware of stock market regulatory considerations and so forth. But putting that minor quibble aside, I do think it was very valuable from two perspectives to be responsible for the minute taking through my organization and acting essentially, though we don't call it that in Japan, as a company secretary, managing the agendas of the board meetings, the board, the board kind of calendar for the year. All of that, I think, ultimately, though it sounds nitty-gritty in its detail,
a lot of work,
is I think a very strategic aspect of the role. And at the same time, as far as the minutes go, which I think is the second part of your question, I think that's a whole separate discussion, is how do you best handle minutes and so forth. But I do think there's a very strong value to the general counsel, if there is a general counsel, as I hope there would be in all companies, to the general counsel having the ultimate voice in what those minutes say and how they're written. Because those minutes, as you know, can very easily be discovered in litigations and investigations, especially overseas. And I think a lawyer is always going to look at those with a much more nuanced eye than the the business people are likely to do.
Worst case.
Right. So I guess I don't know if you're talking about being on the board doing that or just doing that role as a general counsel. And there's pros and cons to each of those as well.
Well, I guess I know you answered a lot of my question very well. Thank you. I guess the one thing I wanted to wonder about is it easier to perform, the governance related, but it's also very legal, as you say, types of function if you are on the board versus not being on the board?
Well, as you mentioned in your introductory comments, I think only a small percentage of general counsels in US companies actually sit on the board. But they always, I think, for the most part, sit in the room and are acting as company secretaries, even if they're not members of the board. I think that is very important. But I think in Japan, there is another factor which makes it very important, I think, potentially for the general counsel. And the first thing is there a general counsel? Is there somebody doing that job? That's important. But I think there's another reason that it may be good for the general counsel to sit on the board, which is that historically, most Japanese companies have not, unfortunately, weighed the role of legal at the same level as finance or HR or other functions.
Right.
And usually legal in many Japanese companies still today reports to the CEO of their business division or subsidiary or the company through some other function,
Right.
whether it be finance, strategy, or planning, or whatever. And I think it's really important for top business management, starting with top business management at all levels, for them to see legal as really having an equal voice at the decision-making table. And so by putting a general counsel on the board,
Right.
As you know, Panasonic did. I mean, Lixil was a different situation because at that time we had you know, an audit committee, I mean, what do you call it, an Inkai Sechigaisha, committee-based structure with a monitoring system with an executive officer board or committee. So that's the kind of served in tandem with the board. And as general counsel, I sat on that. But I think it's very important in terms of the message it sends all through the organization for the general counsel or chief legal officer to have that kind of status on the board or the equivalent. I think that's a reason in Japan that may weigh, in my mind, in favor of that.
No, I think that's very well said. You know, the as you know well, in Japan, often lawyers, either practicing or not practicing anymore, but Japanese lawyers sit on boards as outside directors. And my personal sort of reaction to that is that can be useful, but we have a limited number of board seats, and if it was me and I wanted to make sure we got good legal perspectives on the board from someone who also had a director duty hat on of accountability, I'd prefer to be a general counsel who's full-time thinking about that aspect, as opposed to part-time outside director. So I mean, in place of an outside director who is instead of an outside director who's an attorney, taking one of those few spaces among the outside director group, I prefer it to be a general counsel. Would you agree?
Well, I don't think it needs to be mutually exclusive. There's starting this past year, I think it was there, or last year, there needed to be as you know, a chart that shows the diversity of your board in various meanings of diversity. And I think the legal perspective within that mix is still potentially very important. I think it also gives the general counsel, assuming there is one again, somebody to kind of touch base with informally. Of course, you have to be careful that you're not sharing more or less information with different directors, but to seek input from, because one of the challenges that outside directors always face is that they don't have the same level of in-depth knowledge of what's happening day to day. So to have that kind of just voice of legal support on the board, I think may be a good thing. But I understand that there's many things that need to go into the mix of what constitutes diversity of perspectives. So if you have a strong general counsel and a strong CFO, you don't necessarily need to replicate each of those types of positions on the outside membership of the board.
Thank you. So what about, just to sort of shift gears here, what about ensuring that all members of the board receive enough legal advice of any type or updates, information to do their jobs properly? Sometimes I feel that we outside directors don't get enough such advice on a sort of a one-to-one personalized basis to the extent we need it. I feel like I may not need it, but that person may need it, or the other people don't need it, but I need to know more about XYZ. And there isn't, if there's no general counsel, I'm not sure who to ask, and I may end up asking my own personal lawyer, but that gets expensive. When you have a situation where you have a conflict, potential conflict with a company, say you're talking about the indemnification of you as a director and that sort of thing, you need to go to your outside counsel. You really can't have this discussion with internal counsel and necessarily expect the same point of view of advice. What do you think about such situations, in terms of making sure all directors have enough legal advice that they need? Is that one of your roles?
Well, yes, but I think that starting with the back end of your question, I think the conflict of interest question, that's again, in my mind, an argument to have a strong general counsel, because the sophisticated, strong general counsel will recognize those potential conflict situations.
Yes.
Right, and that general counsel then will proactively recommend to the board,
right,
or to members of the board that they should consider having their own counsel.
Right.
Right, but I don't think that sophistication comes naturally in the way many companies are currently structured, such that there is somebody to tell them to do that.
No, I completely agree. Yeah, I couldn't agree more. It's one thing for you to advise them that, well, for minor things that Nick wants to ask questions about, why don't we just reimburse his personal lawyer expenses as a general policy? It's one thing for you to advise the board that, and they may just listen. But if Nick raises his hand and asks for personal reimbursement, it sounds a lot different, doesn't it?
But I think, I agree. But I think the other thing, and this is what I meant by the back end of the question, I think there's a front end of the question as well, which is, what are your day-to-day board processes, communication processes, protocols for escalating issues to the board, even when they may not be required, and these rules the KESI rules should be reviewed regularly, but what kinds of issues need to go to the board for reporting or resolution, and even more important than that, how do you make sure that your executives in their business presentations to the board are actually covering the important issues, including the risks and opportunities that they may be not necessarily recommending for.
Right.
And, I think there's various ways to do that, including, giving the board advance access to the materials as much as possible. That's not always possible because of emergencies and what have you. But then also giving them summaries of executive decisions that are made at the next lowest level, so that they can see what the risk factors or opportunities that were not chosen in favor of or considered to the degree that some people might think, that they're at least aware of those when the discussion comes to the board, such that they can more intelligently assess the situation and ask questions. So I think that ongoing communication process is extremely important. And I do think the general counsel acting hopefully in a role also as the informal secretary or minute taker will consider that part of his or her duties.
So what would you respond if I asked you, is there a case to be made that it would be good for Japanese companies to consider having also a corporate secretary in the more sort of expanded role as it sort of exists, particularly in the UK, in addition to general counsel?
Well, for whatever reason, and you've been involved in this for years, but the corporate governance code and the company law do not contemplate a specific title of company secretary.
Right.
So, to me, that's not really the important question. I think de facto in my most recent company, we have a group, within my vision that report to me who handle that kind of responsibility. So whether they're called company secretary or not doesn't really matter to me, as long as you have someone who is responsible for carrying out those duties in a proper way.
Right, right. So it's more like what's more important than the title, obviously, is the recognition of the need for the role and making sure that people with the right expertise actually performing it in a robust fashion. That's what I could totally agree with. So I'm going on. What role did you play? Irrespective or depending on the company, with respect to working with various committees of the board. The three main committee functions, particularly. At some Japanese companies, the Kansekai or the audit committee has its own outside counsel that it may use. And I'm just curious, did you coordinate much with the committees, work with them?
So, the two Japanese companies I've worked for are fundamentally structured differently in that regard. So, as I mentioned earlier, Lixil was a Iinkai Sechigaisha with three committees,
right?
Statutory, and they, in that company, I worked extremely closely with the audit committee in my role as general counsel and also for a time as chief risk officer. So there were regular meetings where we would go deep into the issues, the investigations, what have you, that created, I think, facilitated that kind of discussion. Panasonic is a Kansai Kaisha still, even in our new structure as a holding company, which we implemented from April 1st. And there is no formal statutory committees, that I just described at Lixil.
Right.
There has long a nominations committee, which was not statutorily established, but established by the board to de facto fulfill that role. And as we went to the holding company, there's also an informal executive level audit committee working more closely with the statutory auditors. And I think the idea is if you don't have that kind of audit committee where there is that statutorily imposed level of communication, you need to create the infrastructure within the wider organization that supports those roles of audit. And then those need to be reviewed and reported to the board on a regular basis. So I don't think there's one size fits all situation there, but I think in either case, and this was true at Panasonic, even where we didn't have in this new structure, a statutory audit committee, that the general counsel and the CFO were co-chairs of the internal audit committee. So the general counsel, I think, should have a very important role in that, and it also needs to be closely coordinated with risk function. In what are the areas that you're looking at, hopefully systematically with prioritization of the right resources, and that discussion is being escalated to the board as need be.
Got it. Thank you. Good answer. So whether there's a GC on the board or not, how do you ensure the improvement or a constant improvement of compliance in a large global Japanese company? What sort of changes in infrastructure, training, rules, discipline did you make at Lixil or Panasonic or the GE subsidiaries? And in your view, what do GCs or legal and compliance groups in Japan, Japanese companies, need to focus on more, perhaps, if you could dare say?
Well, there's obviously no simple answer to that question.
Sorry.
And no, but compliance infrastructure and vision is something that's obviously multi-year, and you're always aspiring to something, hopefully, to be better. Because there's never any sort of perfect world, considering all the external forces of enforcement and globalization in many different countries, and your own internally changing business models, which are changing all the time and even more quickly now in the digital and artificial intelligence world we live in. So you know, it's an ongoing process. But I do think, and in my old days at GE when I first joined, the Department of Justice, U.S. Department of Justice, you know, bribery-oriented compliance infrastructure, sentencing guidelines, where you would get credit if you had a violation and you had certain key elements of the compliance infrastructure in place. I think those have, in the U.S. itself, now been extended to other areas like trade sanctions violations and to antitrust, and they are also globalizing. So you see countries in many spots around the world essentially developing very similar or looking a lot like these U.S. compliance guidelines, and you know, it may only be a matter of time before Japan itself does the same thing.
Right.
But I say it, but it doesn't necessarily matter for a global company whether Japan immediately does that or not, because we're operating in so many of those jurisdictions that everybody should recognize that we need to essentially put in place the things that are covered in those U.S. guidelines.
You need to match or meet the highest common denominator, don't you?
I think that's right. It's otherwise you're just going to get hit over the head with something surprisingly somewhere.
Right.
So you need to have this this broad infrastructure. And so, I mean, the first things I concentrated on, I think whether at Lixil or at Panasonic, but we spent years on them in GE in Japan as well, are things like having a really robust hotline and the messaging around that, such that you know, people in the ideal world, everybody would be reporting or talking to their managers, to their legal advice, their legal or compliance or HR or finance people if they're there. But we all know that people are afraid to do that from time to time.
Sure.
And they need to have a place to go. And that hotline structure is really fundamentally important.
Sure.
And constantly got to get attention and be communicated all the way down to middle and lower level management, such that they communicate it to their own. You've got to have, we were just talking about it, audit structures. You've got to have appropriate resources. And so that's an issue I think we face in many Japanese companies. I mean, US companies, European companies too, but in Japanese companies, do we have proactive budget to hire the types of expert resources that we need to, and also to have proactive budget to consult outside counsel when there's not a crisis, so that we avoid those crises.
We talk about in advance.
And then in each policy area to have the right training programs, the right risk identification programs for new issues that may be coming up based on external trends or external business models. All of that infrastructure, I think, is well laid out in these US guidelines, which have now become more globalized. And I think that's really a good reference point for what we should aspire.
It isn't a lot of it not just in, of course, what's in the guidelines and the structures and the responsibilities, but also, you know, the part of the job description of all sorts of people is missionary work. You know, you mentioned training, you know, constantly going out there, meeting with groups and stressing what's important and values and integrity and, you know, report quickly and all these things which are obvious. But if you don't constantly, I don't want to say harp on them, but do this, spread the religion in some sense of why compliance is important to you yourself, and what, you know, that you're part of that accountability structure here. Isn't that essential?
I think it's the passion that you need to have to communicate. I think is a really important qualification of a general counsel or a chief compliance officer. But think it goes way beyond the legal and compliance function itself. I mean, but this starts with the legal and compliance function,
Right.
and with the CEO and with the board. But this passion and making people believe that you're serious about what you're talking about
Right.
needs to come from them too.
Right. Right.
And that needs to be felt by people within the organization. And, you know, I think if I go back to my early days in GE, and Jack Welch was, you know, criticized and praised for many, many things. But one of the things that we often got jokingly a little bit tired of within the company was that he repeated himself over and over again
Right.
on the same pithy little phrases,
Right.
wherever,
Right.
you know, and he said it would take that for 2 years in
Right.
order for it to pass a very large
Right.
organization.
Sure.
And I think you can never get tired of communicating those things. And I think it should be done in a way that is hopefully fun, with concrete examples,
Right.
not being afraid to tell your war stories in an appropriate way, so people can really understand at all levels how these issues might pertain to their work individually, personally.
And isn't there also, or do you agree, would you agree that there's also a example setting effect here, that when something does go wrong, when someone does do some sort of malfeasance or retribution for reporting and that sort of thing, it's very important that we visibly, I hate to say it this way, but I think it's true, punish that person per our rules, because otherwise we're kind of not telling people it is safe to report.
Well, it's a really good point, and probably something that I've spent more time on in my career than I ever would have imagined, especially in Japan.
Not surprised.
Because I think the natural tendency in Japan is to, when there's a compliance violation, especially if it's not a legal violation, but a violation of policy.
Right.
So nobody's going to go to jail for it.
Right.
But there's a tendency to say, well, if I take disciplinary action against this person, will he or she turn around and sue me because the Japanese labor laws are so protective?
Right.
And, you know, the answer to that question may sometimes be yes, but, you know, my view of it after 30 years of doing this in Japan is that the message is sometimes more important than that risk.
Yeah, than that cost. Yeah.
And the risk is sometimes overstated, because most Japanese employees, in my experience, if they've been in this kind of a situation and senior management buys into what you're trying to do in terms of taking the disciplinary action, will understand that they have to accept it because it's a loss of face and they just have to do it. They're not going to sue the company 9 out of 10 cases in my career experience. And, you know, I think that messaging is very, very important to show that we're putting our money where our mouth is. And I think there's another aspect to it in a global company, which is that it's very relatively more easy to fire or take disciplinary action against your employees in the US or even Europe or China as compared to Japan. And if we're not doing that, most of these cases are global. And if we're not doing that, then why is it fair that these employees should not be punished in the same way? So I know this is a very difficult discussion, and we have to have it, though. And I think our roles as General Counsel and embed that into the process with our HR and senior management colleagues.
This is a really big issue in Japan, in my view. You know, to me, it'd be very helpful to have a guy like you on the board or in the room, you know, sort of, if you forgive me, sort of supporting me when I say we need to punish people who come anywhere close to retribution. If you don't show people that there is a distinct impact, negative impact from non-reporting or retribution, we belie or betray our own stated values. Just to shift gears, you do mention that, of course, we're in a global world, and so Japanese law, of course, is not everything they control. There are lots of other jurisdictions we control, and we have to reach their highest common denominator. But did the fact that you were not a Japanese lawyer ever cause you difficulties, and how did you address that, if so?
Well, that's an interesting question. I would like to see many more Japanese lawyers doing these kinds of roles, because I think if they're doing it, as we've been talking about, I think that would add that much more credibility to the serious, that we take these issues within the system. I have never, in my roles, felt it a disadvantage to be an American lawyer. I feel it a disadvantage not to be as fluent in Japanese as I should be. I do well.
I do too.
But thank you. But
it's not just
but I don't I don't think that the role of general counsel needs to necessarily be, as I mentioned earlier, a licensed lawyer of that particular country. The issues we deal with in a global company are global.
Right.
And the Japanese lawyer or the American lawyer or whoever is not going to learn the whole world of law.
Right. You can't be registered everywhere. Right.
Licensed program that they get or in any law firm that they work in.
Right.
So that's not what's really critical. And I think in most of the organizations I've worked in, that has come to be understood. Sometimes I feel it has been an advantage to be an American lawyer in Japan, because I think there is an expectation by top management that in hiring me in the first place, I will speak out and bring that sort of global perspective in a way that others may be more reticent to do. And I'm not saying that's the way all Japanese lawyers would act, because I think many do. There are many on this call who would, bring the same things to the table or more. But I just think that there's a perception that in some organizations, sometimes you need the voice of an outsider, and an American lawyer kind of fits the bill, maybe even as the first function in some cases in which to do that, to bring in this perspective and to talk more openly about all these issues.
There's a benefit to that, absolutely. Kind of similarly, and I hope you don't mind me asking this a little bit personal question. Do you think attitudes to diversity and inclusion in Japan are really improving much? And in your own personal case, was the fact that you are a gay foreigner ever something that caused an issue or an obstacle in say the last 15 years?
Well, you don't know what you don't know. So people may have embedded bias perspectives, and I do think this I've forgotten the technical term for it, bias training that is offered by many consultants today is a very good thing to do to get people to understand what their inbuilt biases might be. So I don't know what I don't know, but putting that aside, I haven't directly experienced that. I probably, in the early days, there's a time equation here too, because the world has changed dramatically, especially on LGBT issues in the last 30 years. And so my early days in GE, it was no picnic, right? Many of the GE businesses are based in remote parts of the US where it was not one of the first places, shall I put it, to put LGBT equality on the table. Then you have in the US, though, both for gender and for LGBT and other protected classes, law. It's not perfect, we have issues, but you have law that drives the discussion. I think in Japan, there has now become a greater recognition of the importance of diversity, broadly speaking, And you know, I like to think of that as diversity of thought, because people have many different backgrounds, whether that be nationality or gender or sexual orientation or you know, ethnic or racial minority status or
educational background.
Educational, being from outside the company at mid-level career. I think all of that is diversity, but the way Japanese companies have to approach it is by making that business case why that's important in a world going global, because it's not really a compliance issue in the same way that I think it is for many US companies in the US. Where you can be sued tomorrow for an infringement. So, you know, I think it's a complex question, but, you know, I really think that we have made progress in Japan, but it's been painfully slow. You know, I'm very frustrated that the numbers that were set out at the beginning, you remember, in Abenomics and Womenomics for women executives in Japanese corporates are still extremely low, way below those targets. And I think that raises certain questions. And we still don't have marriage equality, despite an ACCJ viewpoint on that subject of several years ago. So things are slower in Japan. And I think there's the problem or the challenge is that we need to make a business case more effectively than we had if we can't do it politically or legislatively. This is important for Japanese companies to globalize.
I couldn't agree with you more. I think that the business case, I mean, to be a little bit frank and blunt about it, a lot of Japanese male executives really just don't get what the advantages of diversity inclusion are for they themselves and the company. Yeah, it's slower than it should be.
But I do think the world is changing. I mean, I look at recent Japanese companies, and you know, I think top management, by and large, understands the importance of this and really wants to drive it. They don't always know how or agree on the best way forward. And I think there is I mean, in these larger organizations, there's a very deep issue within middle management as to how to really get their understanding.
Exactly.
And I think that's compounded in an environment where you want your company to become more competitive and profitable from many angles. And, you know, there's fears that people have for their own jobs if we emphasize the diversity angle too far. So, you know, really tackling that question head on within middle management, I think in many companies is the challenge.
Well, these have been great answers to a lot of pesky questions, Larry. Thank you very much. At this point, I'm sorry?
I've enjoyed it.
Oh, well, I'd love to go on, and I got a lot of other questions, you know, I haven't asked yet, but we'll get on to those a bit later. Hopefully some of them anyway. Right now, we will take a 10-minute break. And so I would ask if everyone could come back. Don't log off, just turn your screen off or whatever, and come back at 10:53 after the intermission. And we'll have a roundtable, including Yumiko Ito and Hirata Sensei. Thanks very much, Larry. We'll see you in 10 minutes.
All right, see you soon.
See you soon.
Hello.
Hello.
Hi, how are you?
Good. How are you? Good evening.
Great to see you.
Hello,
Yes.
Yumiko-san.
Hi, nice to meet you.
Very nice to meet you.
So welcome back, everybody. I guess we all friends, and I think Larry, at one point you hired Ito Sensei. Is that correct?
Yes.
We were colleagues.
Your colleagues.
Yeah, longer ago than I care to think, but yes, he's a trailblazer.
Three-way colleague matrix here, and I worked with Hirata-san and other things, so we're all colleagues. To the audience, I'd like to introduce our estimable powerhouse female participants in the roundtable discussion we're going to have now. First, Ito Sensei is attorney at law at her own office and independent director at Kobe Steel and also Santen Pharmaceuticals. And she has served, not only that, but she served as the general counsel at Sharp and also as general counsel at no less than the three Japanese subsidiaries of major U.S. companies, including Microsoft and GE Medical. So welcome to the webinar, Ito Sensei.
Thank you very much.
And next to introduce Hirata Sensei, who's been helpful to BDTI and myself over the past. Thank you for your help. She is the head of ethics and compliance in Japan for Takeda Pharmaceutical and also a member of the global ethics and compliance leadership team, and has served in the past as chief legal officer and corporate secretary and statutory auditor, or statutory executive officer at MetLife and head of legal at Invesco Asset Management. So welcome to the webinar, Hirata Sensei. And I'd like to start off by asking the two of you, I'll start with Ito Sensei, if you could simply briefly comment on what you see as the role of the GC, the General Counsel, or the emerging and changing pattern, the way it may be changing in Japan. And of course, in Hirata-san's case, I'd like to ask you not only that, but sort of maybe ask you to explain what are the benefits of an ethics and compliance role and having a separate person in charge of that. Ito Sensei, could you make some comments?
Sure, thank you.
Thank
you. Before I make my comments, maybe I'd like to share a couple of interesting data points.
Great.
I think the one is according to the recent survey by Keiho, it shows that the 33% of the companies with more than 100 billion yen statutory capital have the executive level legal person.
Right.
I don't know which is big or not, but
that's fascinating. Could you send that data over later on? We'd be like
sure.
To read that more. Thank you.
The point is the number of companies that have an attorney board member from management is 18. It's 1.5%.
That's not very big.
It's quite small, and perhaps I know that everybody of 18. So anyway, I think that to your question, the role of the General Counsel, I would agree that Larry's comments, which is to improve the institutional legal capability as a whole organization. And that is very important. And in fact, the General Counsel is now the people in particularly in the corporate legal community know now that importance, and also the Ben Heinemann's analysis that roles guardian and business. But the interesting to me is the business partner role seems more highlighted.
Right.
And I think one reason is that the conventional legal departments are quite conservative and not really work with the business to promote their business. But having said that, but I think if we forget the guardian part, it's quite risky. But that is, I think, a sort of the situation in Japan. And another thing that I want to highlight is that I think every company should have a single person
Mhm.
who is accountable for
Mm.
every legal or regulatory compliance aspect.
Good
And
point.
that is, I think, from my experiences, in Japanese companies, the legal matters that the responsible departments and divisions are quite spread
Yeah, yeah.
organization, and sometimes it's in general in Japanese company, it's not so clear who is accountable, but that such a spread legal function, it's even more difficult to control.
That is
And
a really good point.
I think somebody should be, one single person should be accountable,
Yeah.
and that is General Counsel or Chief Legal Officer. That's a comment to your question. Thank you.
Thank you. I think that's a really good point. You know, I constantly find myself on board saying, basically, who is accountable, solely accountable, most accountable for XYZ? And you've hit the nail on the head there. Thank you. Hirata Sensei, could you add your 2 cents or $2,000 worth?
Thank you. I think it's, well, Ito Sensei actually mentioned a good thing, accountability. So who's accountable? And I think the ethics area, in addition to compliance, is also becoming one of the accountability for General Counsel. So for my company, it's different as a Chief Ethics and Compliance Officer reporting line, but definitely ethics is, it's a booming, emerging area. And we always need to bring in the external lens, as Larry said, and see around the corner to give the right advice and also the right decision making at that time. So we give the support and we also spice up the discussion. So I think that's very important for the ethics role to really embed the corporate culture.
To clarify my own mind and understanding, do you report to the General Counsel, or are you reporting directly to the board? Is ethics and compliance or ethics separately somehow separate?
The ethics and compliance is actually a separate line from General Counsel line. So General Counsel is more purely legal in my current company.
So the company's making a sort of pronounced statement, as we're here, and accountability on your shoulders to elevate the importance of the role of, you know, I don't want to say ethics missionary work, but ethics spreading the faith and ensuring quality of ethics and values.
Yes, yes, exactly.
Very helpful. Please,
so
go ahead.
What I said about this accountability, I think that you discussed the head of law department and legal department and the General Counsel roles and the differences between them. And I think the legal department, that their work is quite narrowly defined.
Yes.
And in many Japanese companies, that is just contracts and some kind of compliance and anti-bribery. But there are many others, right? Which things that have legal or regulatory implications.
Sure.
And so that whether or not the head of legal department is licensed or not, I think there is a gap, the organizational gap between the things that the head of legal department should do and maybe DC should do.
Right.
That I think that here the pretty much value for general that company have to have that General Counsel.
Yeah, this is an excellent point. The just to clarify my own understanding, I mean, the way I think about it is that, you know, you have a legal department often, and you have, you know, Somabu in the General Affairs Department, then you have Yumiko of the board, and you have a guy in charge of compliance who may not be necessarily part of legal department directly. And yes, if you ask who is the single person at the top of some pyramid who's responsible for overseeing and ensuring all of that working properly, every legal matter that pertains to their activities. In a lot of companies, you wouldn't get one name, would you?
I think it's true. In my previous company, I mean, everything reported up to the general counsel. I mean, we call it chief legal officer, but it was the general counsel role in that sense. I worked in that type of companies too. But I think some companies are taking a separate role, and there are some pros and cons for that too. And sometimes it gives awareness to the importance of the compliance, because these days, I think the misconduct is a big issue at every single company. And how do we actually create the safe environment, psychological safety to speak up? So if the CEO and the executives really want to have the proper resource and also the focus in that area, it makes sense. It is a political move to elevate the compliance section and also adding on the ethical task to that compliance officer, in my view.
Well, what is I mean, if I was to be devil's advocate and say, well, aren't we confusing things a little bit if by having ethics and compliance separate reporting lines? Not to put you on the spot, but just to clarify. Now, the reason I'm asking this is that I'm not sure, we say ethics to most Japanese companies. I think a lot of people are not quite sure what you're talking about. The person in charge of ethics. So could you possibly define your role in the ethics area and why it is important in Takeda's case that it be a direct reporting line?
Well, so I see the ethics line as embedding the corporate culture. So the world is getting fuzzy and it's pretty chaos these days. So as well as the business situation. So most of the times we don't really see a yes and no answer or white or black answer. And sometimes people still come to the legal department or even the compliance department to get an answer, black or white. But it's not the case anymore. So we do also ask questions to our business partners. And even at the board or some senior management table, that's our role. I mean, giving a different perspective. Right. And that also, I think, resonate with what Larry said about the diversity. If you have the right diversity at the table, you don't really need an independent director, despite the fact that we have a legal requirement. So I think it elevates the maturity of the organization to have that independent role. Right.
Because it's not all laws and legal and regulations. There's a lot of stuff in values and stuff which is not a direct legal connection. And I'm looking over at Larry now and thinking he probably has some comments and thoughts in reaction to what you both said. Do you, Larry? I'm trying to read your mind.
Oh, mute.
Your mic is off, I think.
I think both Yumi and Inaba-san have some really interesting points, and this is very fundamental, and it goes back in my career as long as I can remember. But I do think there's one thing that we should add to the discussion, and I'm not sure about the pharmaceutical law aspect, but in financial services, of course, we have something called Sarbanes-Oxley, and that sort of explicitly broke apart, at least in US regulated financial institutions, the legal and compliance function. In my view, not for the better, but that's just my personal view. I think we do not have the luxury in all of the organizations I have worked in to separate those roles. We don't have the resources and the expertise at all levels yet bought into, so that we can say to legal people, you're not responsible for compliance. I feel like compliance pervades everything that a legal person does. Ethics, I agree, raises another aspect, which is kind of my second role of the general counsel, theoretically. But I think within compliance, in my experience, where we do not have sufficient resources in a lot of places, it's very risky to say that we should make compliance a separate reporting line, because I think there is a tendency sometimes among lawyers to to say, oh, I like the deal work, I like the positive growth work, and this is Yanabe-san's point, and I don't want to deal with these nasty investigations that may make me unpopular as the general counsel. So I tend to think, as Yumi said, we need to have all legal and compliance issues in the company in one way or the other under one roof. They don't all need to report to me, but I need to have visibility to the finance function for securities law issues, or to the IT function for privacy law issues, or to the quality function for regulatory quality and environmental issues. I need to be able to see all those, and I think breaking apart legal and compliance makes it somewhat more difficult on average for me to do that.
So in your view, it would be more effective and easier for you to do your job effectively if legal, compliance, and ethics all at the end of the day reported to the general counsel.
I think so, but it may be different in highly regulated industries like the one Yanabe-san is facing, where you have a whole regulatory framework that is imposed by the law that needs itself to be complied with. So I am not 100% sure.
Well, as an ex-investment banker who used to do these big swap trades that made millions of dollars and basically ripped the face off of large institutional investors without them knowing what the calculation really meant, I can agree with you that in a regulated industry like that, I wasn't breaking the law, but it was an ethical transgression, I think, in some cases, to be making that much money and the client not knowing how much money you're making on the spread. So there are cases where it's the ethical transgression is not legal. I think that's quite true in regulated industries. I'm curious. This is just a totally different topic, and I've been wanting to ask people like you for years. It may sound amateurish, but we have, of course, in the United States. I'm a non-practicing inactive lawyer, so I know something about this. Not much, but something. We have the attorney-client privilege, which means that you as the general counsel, whatever advice you give or memos you write to the president or the board or anyone else, is protected from discovery. Whereas we don't have that here in Japan. And I'm just curious whether that fact that we don't have an attorney-client privilege in Japan has ever affected your thinking, your behavior, whether you wrote something down in a memo or not. Has it ever been a factor? Anyone?
Who goes first?
It's quite a difficult
Yumiko
question.
was smiling, so I thought she had a comment.
Yeah, as you said, we don't have the attorney-client privilege in Japan, and I should confess that I don't probably really understand the requirements of that, but the more we were exposed to the global risk, particularly the litigation in the US, people got to know that thing, and so that gradually, I think the people start to understand how to handle even the internal communication.
Mm-hmm.
That's still far way to go, I think.
So it protects you in the U.S., in U.S. lawsuits, but it would not protect you here in Japan from discovery, would it? It doesn't happen. It doesn't exist.
Yeah.
I mean, go ahead, sorry. Please.
I didn't mean to interrupt. So if Yumi has, please go ahead, Yumi.
No. Go ahead.
No, I was just going to say, though, that I think there should be a more recognized privilege in Japan for many reasons, because I think it encourages a better approach to compliance with laws, which policymakers ought to encourage. Because I think you'll be less afraid to discuss the issues openly in a transparent way if it's protected. But that being said, I think the US privilege is overstated because in my experience, if push comes to shove, in the US, we almost always, I don't want to say always, we often waive the privilege in order to maintain a cooperative attitude toward the regulator, right? And so I think it's a little bit overstated, and the other thing that I struggled with in Japan for many years is that US lawyers, US subsidiaries, or US parent, when I worked at GE, the US lawyers on the US side are always reluctant to put things in writing.
Right.
And the problem with that is on conference calls or Zooms or whatever, where we're dealing with Japanese and English and Americans talk all the time, like we are right now. Things are often missed in the conversation, and people end their phone calls with misunderstandings and no documentation of the record. And I think we have to have a documentation of the record in order to move things forward. So my theory of it is, yeah, where it's a really sensitive issue, let's do the intelligent thing where there's a really drastic situation. But to move the ball forward in an intelligent way, we need to document what we're doing and keep track of that and get everybody on the same page.
Right.
And there's a risk, yeah, that it may be lost in the privilege, but I think we need to do it.
I guess my thought is, and I'm curious what Ito Sensei and Hirata Sensei think, that something like 20 years ago, I remember the Ministry of Justice was forced by the Nichibenmen was encouraged to propose a drastic improvement in Japan's discovery laws. And they basically proposed in a very convincing memo that Japan have a discovery system pretty much very similar to the US. And as I recall, the Ministry of Justice memo that sort of slammed that and sort of killed it on arrival was only 2 pages long. It basically says, Japan's not a litigious environment and Japan's society is not ready for it. But maybe now we're at the stage where that kind of law might just be passed, come into necessity or viewed to be necessary in the next 10 years. And if so, then a lot of internal communications by General Counsel become subject to discovery. And so what would you think, Ito Sensei?
Well, I think to the extent that litigation is in Japan, I don't think I'm so much feel threatened.
Yeah, not now. No, not now. Right.
Right, and so that's why that we haven't been developing the atomic grant privilege, but recently that I think a JFTC implemented some kind of atomic grant privilege, which is not exactly as the same in the US. So that a little bit the movement to that way, but I think I experienced a couple of times the serious US discovery, and that is to me that totally different from that things in Japan. So
yeah. So we may not go that far, but it could change in the future, and we have to keep just watching this develop as it will.
Association is always advocating to have atomic grant privilege. So.
Yeah, and I think it kind of makes sense because the companies are getting more globalized,
right?
And we will be pulled into some of these litigations,
right? And
I had it in the past too, and we need some convincing explanation, which can be done a little more freely and also flexible with the employees who might be involved,
right?
And have that discussion, proper discussion, and it helps. So I think just something equivalent to the global standard. I think that's what we need.
Right. And you as Blair said, it is obviously very helpful to write things down, and you may waive this privilege later on abroad. And if you think about that, you're more careful about what you write down, but then you don't have enough documentation, we have a problem. So just to wrap things up here, Go ahead, Tyler. Go ahead.
A related question to that, which we shouldn't forget though, which is record retention policies and how long do we preserve email for purposes of forensics or investigations or whatever. And I find that generally Japanese companies do not keep it consistently for long, and that raises another whole question as to how you handle investigations, in particular from US authorities, where I think US companies have already gotten much more used to longer preservation or longer record retention periods. So there's obviously a cost issue to that as well, but that's, I think, another aspect of this discussion.
We need to think about retention more. So to wrap things up, maybe in the next 10 minutes, I'd like to ask each of you, chip in as the order you want, or I'll assign you, but what advice do we collectively want to give to Japanese boards considering board composition and how to obtain the best legal advice from both external and internal sources? I raised the question to Larry, is it really that marginally helpful to have one of your 4 outside directors be an attorney? Or maybe we should have a general counsel who's not on the board and give that seat to someone who has business experience, etc. What kind of advice in terms of improving legal advice to the board and to the company and compliance overall do each of you consider to be most important that we give to Japanese companies? And the field is wide open. I've just mentioned some examples. Would anyone like to start with that impossible question?
Hirata-san, どうぞ.
Okay, let me start. And I think I ultimately agree to the direction to have general counsel who is a legal professional, but also have a wide expertise of the business sitting on the board, or at least at the highest senior executive table.
In the room.
Yep,
right.
In the room, it's definitely, because it's embody the concept of the diversity now, especially because I think I really like the comment Larry made about, if you have the CFO, CLO, general counsel functioning and representing the diversity at the table, I think the independent, many companies are still counting a lot on the independent directors. But in reality, when the organization get more matured, that role might actually go down a little bit. But now I think in Japan, it's still, we need to force the board to have a diverse crowd.
Yes.
Yeah, and the general counsel, who's not sitting only as a legal advisor, will help that. And as long as that person have a seat at the table, the person has the obligation to speak up. So it will be the role model for every single directors. And also at the same time, putting the guardrail at the table.
So I guess maybe one corollary of that, this may sound overdone from me, the governance guy, is that if that person is not a shikoyakuin who at the end of the day could be labor law, not easy to terminate, but better to be sort of iningata shikoyakuin, right? Or shikoyaku under
shikoyaku取締役員, yeah.
System would be better, wouldn't it?
Yeah, I agree. Totally.
Right. Particularly that person. Great. Thank you very much, Hirata-san. Ito sensei, any thoughts?
I think maybe I would not directly answer to your question, but I think now Japanese companies have lawyers on the board. Many Japanese companies. Another data point shows that more than a quarter has the attorneys on the board. And
many, right?
Many, but yeah, I think that sometimes people misunderstand that the board member attorney is attorney, and that's not the case, right? And
right. exactly.
And the role of attorney independent director is totally different.
Right.
And but honestly, if I'm on the board meeting and some legal regulatory matters is discussed, and then the other people look at me.
Right. Right.
That's not bad thing, but I cannot provide the legal opinion or those kind of thing. And I think a general counsel is living in devils in details.
Right.
But of course, the independent director attorney is not, and so that the people cannot expect that.
Right.
The director, the independent director, as work like general counsel. That is the one thing I want to highlight.
Thank you.
And so what the role and of attorney independent lawyer, I mean the director, and what these people can bring the value to the board is of course the question. And I think yeah, the diversity and business sensible comments and such, of course it's nice to provide, but I think as one thing I feel that I can bring value to the board is if there is some legal or regulatory question, and then I could say that, oh, if this magnitude issue,
Right.
for example, the second opinion
Right.
rather than one,
Right.
or yeah, if we have this kind of compliance issue in the company, and you are trying to fix it with these resources, and I think this is too small. Kind of, I think that the attorney independent director can say.
Right.
And in that regard, I think that we could deliver some value, but don't expect work like general counsel. And so maybe the answer to your question to advise the Japanese companies that have
that's very helpful advice. You know, I think what you said is very humble and honest and accurate. It always bothers me when everyone turns to the lawyer on the board and basically ask, is this contract for the M&A transaction okay? Even though he only started reading it and probably has not finished reading it last night. And as if he's the attorney who can opine on this. And I feel like saying, no, wait a minute. We need an outside lawyer's reputational kanban on this, and full due diligence and all. His opinion alone is not enough. But everyone, I can feel people in the room assuming that if Mr. So-and-so says, oh, it looks okay, you know, do you have a Himan Joko, you know, you have this, you're okay. It really troubles me. So I'm just curious, have you ever said, for instance, yes, I am a lawyer, but I'm not, you know, steeped in all the details of this particular transaction. So don't look to me as the lawyer on the board who's passing off on this. Have you ever? I'm just curious. Have you ever had to say that?
Well, I don't say it such directly, but
right,
like that.
You may imply it, right?
Right.
Or ask for a review.
But it goes directly to Yumi's earlier point about accountability, because in a way, I understand why they would look at me as the executive general counsel, board member, to say, do you agree with this? What do you think about this issue?
Right.
And in theory, any issue that's going to the board from any of our business management, I should have reviewed, and I should have already had input into that question. And if I have a different opinion at that late point, I should be able to express it. But hopefully the issue has been resolved at the executive level already. And so that goes to what I was saying earlier about communication and making sure that even outside of the board, there are structures in place that all of the issues that should go to the board or are going to the board are reviewed with me or my reliable person substantially in advance of the board meeting, so that all these issues have already been surfaced internally at that level. I mean, the worst thing is when it does, and it happens still because we're not perfect, these issues, these questions come up at the board and we don't know the answer, and there needs to be an immediate answer. And sometimes we will be struggling to get that within that meeting. But I don't hesitate to say that, you know, for whatever reason, we either need to come back to you if we have time, because we try to put 2 or 3 discussions on that important topic at the board before it's finally decided. Or, you know, there in that board meeting, I will try to get the answer via the internet or somehow from somebody else. So I do think it's related to accountability.
These are great advice we're getting here. I'm sensing 3 themes, not having refined all of it in my mind yet, but one is global, and everything's going more global, and that has a huge effect, and Japanese companies have to increasingly recognize that on the legal side. Another one is the importance of diversity. Another one is the importance of accountability at the top, one person in charge at an executive level, not just the outside director. Did I miss any major themes that we covered? I think we've given a lot of advice. What am I missing?
Yeah, eventually my advice is to have excellent general counsel as like
Right.
Yeah, with the right mindset, I think. So that's really, I think everybody is struggling right now.
I missed ethics. That's right. I missed the
thank you.
addressing ethics. Excuse me.
It's forward looking, actually.
How could I possibly do that? And Ito Sensei, I want you to know I was not denying the value of having lawyers on the board as independent director, particularly not in your case because you have so much business experience, you know, as general counsel at various companies looking at business issues, but just wanting to explore that tendency to have outside lawyers, many of them on boards, but not have a general counsel. Only 18 with a general counsel is a vast difference. Just want to explore that. Thank you very much, all of you, for participating in today's discussion. I guess we've run our time just a minute, but again, thank you for supporting BDTI in this way. We'll make a video of this and put it up on YouTube, and please send it to all your friends. And to the audience, I'd like to encourage you, please consider BDTI's director training courses and e-learning and the director bank, and also our data analysis and the data we can provide to investors. Thank you all so much for participating, and have a good day.
Thank you, Nick.
Thank you.
Thank you, Larry. Thank you very much.
Thank you.
Thank you.
Everybody, good to see you all.
Ito Sensei, thank you very much. お疲れ様でした。